standard the standard model of law enforcement that most of us are used to is one in which, is this mic working? Yeah. Is one in which law is made either by a legislature or by the precedents of courts. Offenses are detected and prosecuted either by government agents for criminal law or by the agents of the victim for civil law. Disputes are resolved in government courts and the verdicts are enforced by government actors. There is an alternative model of decentralized and privately enforced law, which is historically common, which arguably many or most existing legal systems were built on top of, and which in some form still survives. And I usually refer to it as feud law, a slightly misleading term for reasons that should become clear, but I have no better. And I should start by saying that the word feud has no connection to the word feudal. They are not only have different meanings, they are etymologically unrelated. They just happen to sound similar. And since lots of people, when I talk about feud law, think I'm talking about feudal law, it's worth making that point at the beginning. The logic of feud law is very simple. It is that if you wrong me, I threaten to harm you unless you compensate me. And in order for it to work, there are a number of conditions that have to be met. The first is that you need some way in which the threat to harm you is believable if you have wronged me and is not believable if you haven't. Otherwise it just becomes extortion. I make threats and you have to pay me off. I think of that condition as the requirement that right makes might. That there is some reason why being on the right makes it easier to win the fight than being in the wrong. Second, you need adequate commitment mechanisms. You need some way in which you will carry out your threat to harm someone even if he can defend himself and so it's risky and expensive. And ideally you even need post-mortem commitment mechanisms. Some way that if somebody kills you, someone else will then be committed to harm him so that there will be an incentive not to kill people. You need some way of protecting the rights of weak people, of people who are not in a good position to themselves apply force and harm people. And you need some way of terminating feuds, some way such that if I think you've wronged me, you refuse to compensate, I harm you, you now think I've wronged you, and so forth, some way in which that sequence can be ended. A lot of people, when they hear the term feud, imagine an interminable exchange of that sort. But in most functional feud systems, that's very rare. I think in most of them, most feuds end at the first round, and they very rarely go to many rounds. So let me start by discussing the first of those conditions, which is mechanisms such that right makes might. And I will start with the feud system that I first studied many years ago and still think I know best, although not quite as well as I knew then because there's some new information that I haven't yet absorbed. But that's the System of Saga period Iceland. Iceland was settled beginning about 870, according to the Icelanders, by refugees from the unification of Norway. The legal system was set up in about 930. In the 13th century, there were a series of internal conflicts, and it finally broke down in the 1260s. So it lasted for about a third of a millennium. And in that system, there was a legislature, a law code, a set of courts, but no executive arm of government. So that if I thought you had wronged me, I could take you to court, I could get a verdict. The verdict says you owe me 50 ounces of silver in damages. You either pay or you don't pay. If you don't pay, the court declares you an outlaw, and it is now legal for anybody to kill you. So the basic logic of that system is that once I've gotten the verdict that you're an outlaw, everyone else knows that I am merely enforcing my rights when I go after you, and therefore your friends will be very reluctant to defend you, or even to shelter you, which means that right as defined by having won the court case, in effect makes might. Let me shift from that to a much simpler version of the same system, and that's one that is still functioning. the Roman Chal Gypsies are the largest gypsy group in England. And their internal legal system is essentially a primitive version of the Icelandic one. The basic logic of it is that if you have wronged me according to the norms of our society, there isn't a written law, but the small enough society so that most people know what's right and wrong. If you've wronged me by those norms, I threaten to beat you up. If you really have wronged me, my friends will back me and your friends won't back you. Otherwise, if you haven't wronged me, it'll go the other way around. So if you have really wronged me, either you pay me compensation or you leave town. And I like to describe the current Roman Chal system as a primitive version of the legal system of Iceland 1,000 years earlier. Third example is the system in Somaliland, which is the northern half, roughly, of what is now nominally the country of Somalia. And when I first got interested in studying this, the first source I found was a book written by a Dutch libertarian lawyer who spent the last 12 years of his life, I think, married to a Somali woman and living in Somalia. It wasn't finished at his death, and it was then edited by an American libertarian. I distrust sources by people who agree with me, because it is too likely that if they bias the story in the direction I want, I won't see it. So I went looking for another source, and discovered a man by the name of Lewis, who is, or I don't know if he's still alive, but he was recently, a retired London School of Economics anthropologist who had been studying northern Somalia since the 1950s, and pretty clearly was the authority on it. And his story was not radically different from that of my other Van Noten, although he had much more detail and a much wider picture of the system. But basically in the Somali system, you have a basically oral traditional law, have traditional mechanisms for forming courts, and you have an elaborate and quite interesting system of pre-made coalitions. I'll come back to that in a minute, determining who will support you or who will help you pay damages if you get into a legal controversy. But I think of that as sort of intermediate between the Icelandic and the Roman Chal, since the law is not written but is known, and it is, again, privately enforced and decentralized. And next problem is commitment mechanisms. How do we make sure you go through with the commitment? Let me take a step back a million years or more by pointing out that, contrary to what many people say, property is not only not a creation of the state, it predates the human species. That there are quite a number of what are referred to as territorial species of animals, especially birds and fishes. And the way a territorial animal works is that it marks out a territory it is claiming, and then somehow turns a switch in its brain. How that works we don't know, such that it will fight more and more desperately against a trespasser of its own species and gender who comes into that territory, the deeper he comes. Unless there is a large inequality in strength, a fight to the death is a loss for both parties. Hence, once the trespasser observes the commitment, he will usually retreat. And that is a very primitive form of property. It's not transferable property. There are no title deeds. But nonetheless, it has the fundamental characteristic of something claimed and successfully defended by an individual. I want to argue, and I could go into that at greater length. You can find stuff on my webpage on it, that human rights are simply a much elaborated version of that system, that they ultimately come out of people having a commitment to bear unreasonably large costs defending against certain trespasses. And in particular, what we think of as vengefulness, which is often treated as an irrational passion, is in fact a perfectly functional commitment strategy hardwired into human beings. That if you imagine a feud system, somebody wrongs you, retaliating is dangerous and risky, the fact that you will feel like a wimp if you don't makes you more likely to retaliate. So that is a hardwired internal commitment strategy. There are, in addition, some fairly obvious external commitment strategies. One of them is that being seen to be a wimp costs you status in many societies. One of them is that if you fail to retaliate this time, other people will say, great, we can cut wood in his forest, or seduce his daughter, or or write a poem insulting him. That was a tortious act in Icelandic law. Or give him an unfavorable nickname. That was a tortious act in Icelandic law too, as it happens. Sort of an odd kind of intellectual property right, or unproperty right. But in any case, the fact that that you have a reputation for being the kind of person who retaliates against those who wrong him gives you a strong incentive to do so even where it is risky. A further point, which will come up again in a little bit, is that you get the pattern in a number of societies, including both the Icelandic and the Comanche, one I haven't mentioned, but another stateless society, that sometimes when somebody who is too weak to enforce his rights gets in a problem, someone volunteers to help him. Why? Because the volunteering is getting the champion status. The champion is coming out there and saying, look, there's this big tough guy who has wronged you. I'm bigger and tougher than he is, and I have more friends. I could give examples again from the sagas, but it's a pattern which exists in both societies. And probably in others. So that next you need some mechanism to protect the weak. And Iceland has my favorite solution to that problem, because it was a very simple solution. And that was that tort claims were marketable, transferable. So I am wronged by someone. I'm an elderly man, I have no adult sons, I have no close relatives who will fight for me. So I know that if I try to prosecute the case, I'll get beaten up in the process of trying to go through the legal procedures. So I go to my neighbor, who has 4 strong sons who went a Viking in their youth, and lots of friends and relatives, and I say, I've got this really strong legal case, worth 200 ounces of silver, how do you like to prosecute it? And according to how hard the case is, I may have to give him all of the money, I may have to give him half of the money, I may have to do some other favor for him, it's a really hard case, but I can transfer the case and thus make sure that somebody with the power to enforce it does. And I've been arguing for quite a long time that this institution would be an improvement in American tort law, that after all, when somebody smashes your car on the highway, unless you get your car smashed pretty often, you don't know who's a good lawyer to handle the case. You may not even have the resources to hire a lawyer. You could get a lawyer to take it on a contingency fee, but how do you know which lawyer to do it? On the other hand, if you could simply auction off the case to the highest bidder would be whatever lawyer was best able to win the case and collect the money, and you would then be out of it except as a witness. So I've been arguing for some time that in this particular respect, American tort law is a mere 1,000 years behind the cutting edge of legal technology, as demonstrated in Saga period Iceland. The Somali system had a different solution to that problem, and that is, as I was mentioning before, that the Somali had a sort of a nested set of coalitions. So you were a member of a small group of people who were likely to be your agnatic kin, that is, people with a father, grandfather, or great-grandfather in the paternal line in common, but didn't have to be. That essentially these coalitions were created by some combination of kinship and contract. That coalition was part of a larger coalition, So in the simple case where you have a conflict with somebody that only brings in his low-level coalition, if he's wronged you, the other members of your coalition are pre-committed to help you get your rights from him. And if you've wronged him, the other members of your coalition are pre-committed to share in the damage payments you will owe. If you do it too often, of course, they may kick you out of the coalition for obvious reasons. Furthermore, if you collect damages, there is a formula by which the other members of your coalition share in the damages collected. All of this is set up by explicit, sometimes written contract, which is one of the things I thought was really neat. The contract provides who gets what share of what, in what way. If it turns out that the opposition group is too large for you, you pull in the next coalition up. One of the things I thought amusing is that in the Somali terminology, a coalition that is built only on contract and not on kinship is described as a pile of shields. That was the term the Somalis used for the U.S. alliance against the Soviets. it was a pile of shields. It was only based on agreement. We weren't actually agnatic kin to the Germans, the French, the British, and so forth. And one of the fun things reading about such societies is realizing that we may think they're primitive, but they don't think so. They think that their view of the world is, of course, the right and high way, and everybody else is a little backwards for not understanding things in the same way. Termination of feud. In Iceland, what basically happens is that if there have been several rounds and people are unhappy about it, then neutral parties with good reputation come in as middlemen and offer to arbitrate. And you get somebody who both sides agrees, can give an arbitrated decision, and they will abide by it. My favorite story for illustrating the stability of the system is a bit in Njal Saga, which is one of the most famous of the sagas, where there has been legal trickery of various sorts going on to try to block a legitimate case. And eventually the side that has been blocked gives up on the lawyers and pulls out its swords. And you start having a battle in the middle of the all-thing, of the assembly. And at one point in this, somebody on one side goes to someone who is a benevolent neutral and says, if we're fighting, what will you do to help us? And he says, I'll tell you what, I'll draw up my people armed over there. If you're losing, you can retreat behind them and that'll break up the fight. If you're winning, I'll break up the fight before you've killed more people than you can afford. So the assumption is always that when the dust settles, eventually, if you kill people, you almost certainly have to pay quite a large price for doing so, and that is an incentive not to kill very many people. But it is, typically you get these things settled by arbitration. In the Somali case, one of the things you have are courts, they're ad hoc rather than officially sort of set up, but there are mechanisms for setting up courts to arbitrate disputes. But in addition, one of the things I thought was neat reading Lewis's stuff was there was one point where there had been a lot of conflict and people on both sides were worried about the amount of killing going on. So they agreed to raise the weergeld, to raise the price for killing somebody. And after all, markets work, you raise the price for killing people, fewer people get killed. And I thought that was rather pretty. All right, let me offer my evidence that the feud law underlies a variety of modern legal systems. The easiest case is Anglo-American common law, because Anglo-American common law grows out of Anglo-Saxon law, which is basically Icelandic law plus a king. They're from the same basic legal tradition, and the way you get to criminal law is that the king, observing there's money to be made by collecting damage payment, takes the position that certain offenses are offenses both against the victim and against the king's peace, such as attacking somebody on the king's highway. And the definition of what's an offense against the king gradually expands, thus funneling more of the revenue from law enforcement to the king and less to the victims. It's an oversimplification, but it's basically what happens. But let me give another example, which I thought was quite intriguing, and that's rabbinic law, traditional Jewish law. I believe that Jewish law is probably the best documented legal system in the history of the world. There is a book this thick, the Mishnah, from about 2,000 years ago, which is essentially a law text. Of course, there's the Old Testament, which has some legal rules much earlier than that. And then there is a stream of books, God knows how many, hundreds of thousands of pages after the Mishnah, right? The Talmud, and then a whole lots of commentary that comes out of it. So it's a very, very well documented legal system. And one of the things I found intriguing when I was trying to make sense of that legal system, this is part of a book I'm working on legal systems very different from ours, was the treatment of killing. If you kill somebody, what's supposed to happen is that you go to one of the cities of refuge, you are escorted from there to the city where the killing occurred to be tried. If the verdict is that it was the equivalent of first-degree murder, that it was capital murder, that you deserve to be executed, you are executed by the avenger of blood. Who is the avenger of blood? The heir of the man you killed. That is the person who in a feud system would have been responsible for pursuing the feud. That, of course, I should say, the solution to how you commit yourself past death is that the claim for killing somebody then goes to his heirs, and since in the Icelandic system it's a claim for quite a lot of money, they have an incentive, in addition to reputation, to try to collect and to prosecute the case. If it is found to be a non-capital killing, the killer returns to the city of refuge and is in exile there until the high priest dies. It's an exile of uncertain term. If, however, the Avenger of Blood catches him on his way back, he can kill him. So again, that looks an awful lot like the remnants in a non-feud system of what had been a feud system. Furthermore, the law provides that the Avenger of Blood does not have the option of accepting a money payment in order to let off the killer. Well, you don't make laws against things unless you expect people to do them. And that again looks like prohibiting the weregeld arrangements, which were how killings were commonly settled in the Icelandic system. So I think it's pretty clear that you have there a fairly elaborate legal structure built on top of a pre-existing feud system. In Islamic law, the part of Islamic law that deals with killing or injuring people is called jinayat. The claim is not a claim by the state, it is a claim by the victim or the victim's heirs. It's treated essentially as a tort. It goes to a court. If the court finds the equivalent of first-degree murder, the heirs have two options. They can either retaliate, kill the person who did the killing, or accept diya, which is a payment of a fixed amount counted in camels, various ages, as compensation. If the court finds that it was a less than capital killing, the heirs do not have the option of retaliation, but they do have the option of a smaller diya payment. Or they can just drop the case. They could, agree that they'll forgive the person or whatever. But essentially the case is controlled by them. Now I'm slightly oversimplifying, because killing in Islamic law is not only an offense against the heirs or the victim, it is also an offense against God. And therefore there is also a further punishment which amounts, if I remember correctly, to either freeing one believing slave, that is one Muslim slave, or else fasting for, I think, 2 months. The Muslim fast, as you may know, only means not eating or drinking during daylight. So it's not like you're starving yourself to death. But still an inconvenience, especially in the summer, which many people are going through, of course, in Ramadan. So in any case, so that's a case where I think it's pretty clear that what you have is basically Bedouin feud law, which still also survives independently of this, being incorporated by Muhammad into his legal system. Roman law, the situation is not as clear, because we have very little information about the very early Roman law. The earliest Roman law text really is the Law of the 12 Tables, and the Romans for centuries regarded that as the equivalent of their constitution, and yet no full text has survived. What we have are chunks of it quoted in various other Roman sources, and people have tried to reconstruct it with some uncertainty. So we don't have a really clear idea of what was there. But it looks from the fragments as though it is again coming out of a pre-existing feud system and imposing legal rules on it. And a good deal later in the Republic period, it is still the case that the responsibility to bring the defendant to court is on the plaintiff. That the plaintiff has got to basically drag the defendant to court, and that a good deal of it, again, looks as though within a now more formal legal system, stuff remained. In Roman law, even quite late, first theft was treated as a tort, and only later as both a tort and a crime. I have not been able to find anything useful so far on the origins of Chinese law, which is another one of the great legal systems of the world, so I don't know whether if you go back to the very beginning, there is or isn't evidence that that comes out of the feud system. Let me now discuss modern feud law enforcement, because I want to argue that in the shadow of state law, you still have the logic of feud going on. And the particular case that intrigues me, given that I teach in Silicon Valley, is patent litigation among high-tech firms. Let us suppose you or Apple think that you've got a pretty weak case against Samsung that they are violating your patents. I'm not making a comment on the real cases, this is the hypothetical. And you say, well, if we sue Samsung for violating our patents, two good things happen. First, the court might make a mistake. Even if our case is weak, they might award us a victory. Second, even if we lose, during the time until we lose, people will be less willing to buy Samsung phones because they'll be afraid that if we win, there will be restrictions on those phones, so we'll sell more iPhones. So maybe we ought to sue them. But wait a minute, there's only one problem with this. Samsung has lawyers too. So therefore, if we sue Samsung, Samsung can countersue us for claims that we violate their patents. Consequently, the threat of retaliation restricts, though it does not eliminate, the temptation to sue your competitors with weak claims of patent violation. That's the basic argument. Now, there is unfortunately a hole in this system. And the hole in this system involves what people who don't like them refer to as patent trolls, otherwise known as NPEs, non-practicing entities. These are firms which buy up lots of patents, not because they intend to use any of them. They're not producing anything. They are in the business of collecting royalties and of suing people who they are willing to claim have violated their patents. And it's widely believed, I'm not competent to judge whether it's true, that in many cases they are making very weak claims, relying on the fact that litigating a patent suit is expensive, that you might lose even to a weak claim, and therefore that the people they sue, they hope, will agree to pay them off with a licensing fee, and they can thus collect money. Why does this system permit weak claims in a way the other doesn't? Because the non-practicing entity is immune to retaliation because he's not practicing. That is, a firm that is not using any patents can't be sued for violating patents. Consequently, you have the problem, and it's at least widely viewed, that a large fraction of patent litigation comes out of such non-practicing entities who are not constrained by the threat of retaliation that ordinary tech firms are. Now, I have a solution to this problem, as it happens. And my solution comes not from Saga period Iceland, but a little bit earlier. It comes from Periclean Athens. As I say, I'm working on a book on legal systems very different from ours, and that's one of the legal systems. And Periclean Athens, I like to describe it as the legal system of a mad economist, because it's full of ingenious ideas that might or might not work. But one of the features of that system is that for at least some cases, we don't have detailed enough information to know how many, if I sue you for damages and lose, I owe you damages equal to 1/6 of the amount I claimed. And if you think about it from either a justice or a law and economic standpoint, there is a logic to that. Because as long as you believe that courts make mistakes, suing an innocent person imposes costs on him, even beyond the cost of litigation, which aren't very high since Athens didn't allow lawyers. You had to represent yourself. But even aside from those costs, if there's one chance in 10, we'll make it one chance in 6 to take the Athenian case, that you will sue me when I'm innocent, charge 10,000 drachma, one time in 6 you make it 12,000, one time in 6 you collect, on average that's costing me 2,000 drachma. So it therefore makes sense that if we say that when you win the case we treat that as if I'm clearly guilty, when you lose the case we treat that as if I'm clearly innocent. Consequently, you have sued an innocent person, you have imposed a probabilistic cost on him, therefore you owe him damages. So I am suggesting that if American law introduced this general principle, if it introduced a principle in which when you sued under tort and claimed some amount of damage, if you lost, you owed damages representing some appropriate fraction of that amount to the person you had sued, now the strategy of the non-practicing entity, of the patent troll, becomes much less profitable. So, having discussed the way in which Saga period Iceland explains why we don't have a good many undesirable suits, and why that solution doesn't work for NPEs, I am now pulling out of a much older legal system a method that would work. So I think those are the things I wanted to talk about. I'll be happy to take questions about it. I should say, for anybody familiar with my earlier writing about Iceland, not all of it is correct. After I wrote that article, the surviving collection of legal texts finally got translated into English. I've read them. In some details, they disagree with the picture that I have in the Sagas. I'm currently in the process of trying to reconcile the two. So if you wait a couple of months and read the chapter on my webpage about Iceland in the draft of my current book, you will get a more up-to-date version than the version that I originally published in the Journal of Legal Studies 30 years ago or 35 years ago or something like that. Anyway, so I guess that's it. I've got 10 minutes.
you discussed the what was the patent trolls. I think there's a tendency in the U.S. right now, a trend towards like even patent almost overs by the federal government, in which they are blackmailing companies, federal agencies, the SEC, the FCC, what have you, bring suit against a corporation. It is so costly to defend that the corporation settle. The monies received from that, I'm not sure where they go, in the federal treasury, I guess. But it's a growing trend, and it's a very dangerous trend, much like in the patent trolls. So is there a logical end to that? Is there a way to just now, since you can't sue back the federal government, but you can, but you know, again, it's going to cost you.
Well, you can. There's the situation, as you may know, is that the default rule is that you can't. The default rule is sovereign immunity. And there's something called the Tort Claims Act, which says that for certain subsets of cases, the government is willing to be sued. But if you move to what I'm referring to as the Athenian rule, then presumably it would apply to the government as well, and it would therefore be a gamble from the standpoint of the company, but companies have lawyers too, and if it was really a weak case, they would figure we're going to make more money by winning the case than we're going to lose by losing it. It occurs to me one thing I should have said and didn't. For those of you who are familiar with my first book, The Machinery of Freedom, one of the conclusions I reached after studying all these Feud systems was that I was less original than I thought. That in a sense I was reinventing the wheel. That the anarcho-capitalist system I sketched there was sort of an elaborate modern version of the kind of decentralized, privately enforced system that had existed historically in quite a number of systems. But I didn't know anything about that when I wrote the books. So, another question?
Can you comment about what was the murder rate in Iceland and in these other places compared to other countries that have other systems today?
I think the only one I have anything close to data on is Iceland. And there was a scholar who tried to estimate the number of deaths during the final 50-year period of breakdown. And I'm not sure if he's right. What he was doing was going through the Sagas counting bodies. Because the saga, most of the fighting in the Icelandic sagas is very small scale, so they name who gets killed, injured, and so forth. And if his numbers were right, during the period of breakdown of the system, the rate of homicide mortality was roughly comparable to the U.S. highway death rate. So not very high, although. But a different comparison is that if you take his total numbers, I think it's almost certainly the case, though it's hard to prove it because you don't have good statistics on any of this, that England, Norway, and Normandy lost a larger fraction of their population to violence in 3 weeks of the year 1066 than Iceland did in 50 years of breakdown of the system. Those 3 weeks covering the Battle of Stamford Bridge and Hastings, which people may be familiar with. As you may know, part of the reason that England was conquered by the Normans was that the King of Norway invaded England a few weeks earlier. The army under Harold marched north, successfully defeated the Norwegians, then had to march more or less the length of the country, and then fight a second battle. So we don't have very good figures. I know somebody who's one of the leading scholars of this, Jesse Bayat, and his opinion on the archaeological evidence is that violent deaths were not very common. But it's not like you really have, serious crime statistics for any of these societies. You might for the Roman Chal, I don't know about them. For the Somali, certainly you had people getting killed. On the other hand, things seemed to get a lot worse when Italy and England pulled out from their nominal control, created the country of Somalia as a modern democratic central government country, something Somalia had never had before, and that led pretty quickly to a military coup, which led to a war with Ethiopia, which led to the Soviet Union switching sides in favor of Ethiopia, which led to the dictator getting killed, which led to a general collapse, after which, instead of letting it go back to its natural state, the US, the UN, with Ethiopian troops, attempted to recreate a central government. And they've been attempting to do that ever since. People, especially people around Mogadishu, figured out pretty quickly that if there was going to be a government, it was better to be the ruler than the ruled, and so they've been fighting over who's going to be the ruler. Meanwhile, in the northern half, the locals established what they call the Republic of Somaliland, which mostly seems to have functioned, but the U.S. and the UN won't recognize it because that would be admitting that Somalia is the country. And again, my source on that is mostly Lewis, so it's somebody who knows a whole lot about Somalia and has no obvious libertarian bias, and has a very negative view of the UN intervention.
Thanks. The homicide statistics is really surprising, but my question is about the cost of enforcing the laws. So do you think that the transaction cost involved in the private orderings that you described is better or cheaper than the transaction cost involved in the public ordering and enforcement?
I think that's very hard to judge. That is, these are all, we're looking at societies which are all by our standards relatively low population and relatively primitive, and it's very hard to compare that with a modern society. That, in a way, it's sort of hard, you could even argue that some of the cost is negative. If you read there's a 19th century comment on how amazing Iceland was, which ends up by, they produce a great literature. I don't know how many people are aware of it. When I talk about the sagas, these are histories and historical novels written down 700 years ago in a country with a population of about 50,000 people, and there are probably a dozen of them currently in print in English translation. So you're talking about one of the great literary success stories of history. As if you think about output that still is being read per capita, that's the size of a medium-sized suburb. But one of the 19th century commenters said, it's amazing that such a rich and interesting society occurred in a place where people's main entertainment was killing each other. And my response is he's wrong. Their main entertainment was suing each other, and they only had to kill someone once in a while to keep the lawsuits going. But certainly if you read the sagas, you have the impression that to some degree the conflict associated with the system really was a form of entertainment. That it was, it was what people argued about, and there would be a few people in Iceland who were experts in the law, so expert that no case was really settled unless they had a hand in it, and you would try to get one of them on your team, so to speak, and so forth and so on. But the real answer is the society functioned. It didn't obviously function worse than contemporary societies such as Norway, which had a king. Beyond that, I really don't know.
We have time for one more question.
Hi, thanks a lot for that talk. You've mentioned a bit about the court system and the law enforcement things, and I was just wondering what your thoughts on who is it that creates the laws, who sets the punishments, or how the punishments are actually set, and in your ideal anarcho-capitalist world, what laws would do that?
As far as the societies I'm describing, in the Icelandic case, you had a legislature. The way the legislature was set up was that there were people for whom the Icelandic term is gothi, which is usually translated chieftain, but that's a very misleading term because there were no tribes. A gothi was somebody who owned a property right that let him play a certain role in the legal system. So basically, in order to plug into the legal system, to sue and be sued, you had to be the thingman of a gothi. But you could freely choose any gothi, at least in your quarter of Iceland, who would have you, and you could change from one to another. I've sometimes described it as franchise feudalism in that sense. The right to be a gothi was a transferable property right. You could leave it to your heirs or give it or sell it to somebody else. The legislature essentially was made up of the godar, that's plural of gothi. And that legislature made or amended the law. So that's how the Icelandic system worked. The Somali system, as far as I can tell, it was really a much more informal procedure. There was traditional law. If a judge in one of these arbitration cases made a decision and everybody thought it was inconsistent with the law, nobody would ask him to arbitrate again. If he made a decision that seemed right to people, maybe other judges would copy it. So it was a sort of an informal, not quite precedent, but something like that system. And the Roman Chal, I think, again, is just community norms most societies have, and we don't know how they went. In the system that I sketch in machinery, what's happening is that you have private rights enforcement agencies, which are the people who you pay to protect your rights and settle your disputes. Each pair of such agencies operating in the same area know that their customers will occasionally have conflicts with each other. So each pair, in order to avoid the uncertainty and expense of violent conflict, agree on a private court that will arbitrate their disputes, agree in advance. What enforces that agreement is repeat dealings. The fact that if we refuse to go along with the verdict when it goes against our client, you won't go along with it when it goes against your client. Both of us would rather have a system where you win the case when you're right and you lose it when you're wrong than one where you win or lose at random, because that's a better product to provide to our customers. So then the rights of the courts, the arbitration agencies are generating legal codes. They have an incentive to generate the legal codes that the rights enforcement agencies want to buy. The rights enforcement agencies have an incentive to buy the legal codes that their customers want to live under. The customers have an incentive to be at least moderately well informed, because unlike a political situation, you can change by switching which agency you patronize, and it is easier to be well informed because they can observe how the different competing agencies are doing, unlike the political situation.